Hi everyone, and welcome to our second session in our Tea and Telecoms web chat series. Just on the series generally, in the first session, which is still available for download, we looked at what challenges and opportunities there were in the UK for both wireless and fixed line operators. And then going forward for this session, our tech and regulatory colleagues in Brodies are going to explore just how the UK can transform itself into a new digital world and how the UK can future-proof telecoms technology. So make sure you're listening to those. Turning to our immediate matters today, we've given ourselves an enviable task of looking at the UK legal framework for telecoms, and we'll look at the divergence of the Scottish and English jurisprudence in the area, the various valuation methodologies that have come to the fore, upgrading and sharing rights, and the new draft legislation following the not so recent government consultation into the code. Here today is myself, Lucy Barnes, Scott Logan and Gareth Hale, all from Brodies, and specialist telecoms barrister Oliver Radley-Gardner QC of Falcon Chambers. Scott is a legal director in Brodies real estate team with a long track record advising and acting for telecoms operators and site providers in Scotland. Gareth is a partner in our real estate disputes team and is published in leading telecoms texts. And I'm a senior associate specialising in telecoms matters in England and Wales. And I suppose it perhaps goes without saying for most listening to this web chat, but Oliver is a leading counsel for all manner of telecoms issues, acting foremost on behalf of operators with disputes in England and Wales. And we're extremely grateful for your time today, Oliver. So thank you for joining us.
Thanks very much, Lucy.
No worries. Without further ado, let's get into it. So looking at the divergence sort of north and south of the border, Scott, what's been happening there?
Well, thanks, Lucy. Well, for me, the key divergence north and south of the border is in relation to leases which have passed their contractual expiry date before the new code came into effect. And I use my language carefully here and avoid making references to expired leases, which can get a bit confusing there. So just starting, we had in England and Wales, we had our Kiva and AP Wireless, one that we'll come back to again shortly, in which the upper tribunal ruled that a tenancy at will that followed on from an earlier lease that had passed its expiry date before the new code came into effect was not a written agreement as required under the code, and it was therefore not a subsisting agreement for the purposes of the transitional provisions from the old code to the new code, and therefore the renewal procedure under Part 5 was not available to the operator there. So the end result being that the operator was locked out of the code there with nowhere to turn. Then we had very similar circumstances in the Scottish case of Duncan. Again, here we had a lease that had passed its contractual expiry date before the new code came into effect and was continuing from year to year by tacit relocation, which is a Scottish concept where leases continue on an implied basis after their expiry date unless a notice to quit is served. Both the Lands Tribunal and then the Inner House on appeal ruled that a lease running on tacit relocation is a written agreement, so obviously clear difference there, north and south of the border. And it's simply the same lease extended year to year until such time as a notice to quit is served. So again, here lease was a subsisting agreement, and here the Part 5 renewal procedure was available to the operators. It's also just worth mentioning here that tacit relocation only applies to leases in Scotland and does not apply to true licenses. So given many rooftop agreements are set up as licenses rather than leases, that may be an area for future disputes when agreements for rooftop apparatus are coming up for renewal. Another key point in Duncan was the test for obtaining Part 5 renewal. Here, the Lands Tribunal set the bar too high in requiring the operators to justify renewal in terms of site-specific needs or unusually onerous terms of the existing agreement. This was overturned on appeal by the Inner House, taking the view that the benefits of having a new code agreement with new code values was justification enough, and there was no need to demonstrate site-specific needs beyond this. And that neatly leads us on to the recent English cases that followed on from this. And Oliver, do you want to pick up there?
Yeah, thank you very much, Scott. We'll probably get to the challenges that English law has faced arising out of oral agreements when we get to an outline consideration of the recent appeals in the Supreme Court. But suffice to say that tacit relocation has made all the difference. There is differential treatment north of the border and south of the border, in the sense that in English law, if a written fixed-term agreement which has been contracted out of the continuation provisions of the 1954 comes to an end, and if, as is seemingly very common, the operator simply remains on site for a period, sometimes a significant period, and the automated rent payments are paid out and accepted by the landlord, then in those circumstances, because English property law abhors a vacuum, it applies one of two explanations for that accidental relationship. Explanation one is if there's evidence of some kind of negotiation process, then what will be inferred is a tenancy at will, which is in English landlord and tenant law pretty much the standard response to occupation coupled with rental payments plus negotiation. But if the relationship has proceeded for a very long period of time, or if one can infer the parties have decided just simply to proceed on a periodic basis, an oral periodic tenancy may be inferred from the payments. It's a question of fact in each case. But the net effect of that is that, unlike in Scotland, where tacit relocation considers that simply the written agreement has continued, in English law, those are treated as entirely new unwritten agreements. And as we code enthusiasts know, if it ain't in writing, it ain't a code agreement. And you're therefore frozen out of all of the renewal provisions under Part 5. And if you're a periodic tenancy, you're also not entitled as a periodic tenant to initiate a 1954 Act renewal process. And as a net effect of that, this basket of cases, of which I think there are a significant number, are with any statutory protection in England. So query whether that was the intention, that there should be this differential treatment in effect between Scotland and England and Wales due to the happenstance of the features of each jurisdiction's law of real property and leases. The English cases on the second issue that Scott has illuminated have also followed essentially the appeal decision in Duncan, in the sense that it's not suggested there is any specific high burden or special burden that has to be overcome in order to establish that a renewal agreement is what should be imposed. There is a menu of things the operator can select in its notice in terms of the shape and form of the agreement it wants, and the tribunal has a residual discretion as to choose what the most appropriate ones of those is. It's probably worth pointing out also that under the Part 5 process, because Part 5 is predicated upon the operator still being there already under an agreement, there is a presumptive satisfaction, if you like, of the paragraph 21 test. In other words, the operator has the benefit of it being assumed that it's there, and it's actually for the site provider in giving a termination notice to put the paragraph 21 test in issue. So as Scott has pointed out, really on renewal, the dynamics are very different from an imposition, because it then falls on the site provider to show one of the grounds, essentially two bad behavior grounds, redevelopment, or the suggestion that after all the operator would not were this to be a fresh imposition to satisfy para 21. So there is a bit of divergence between the Scottish and English and Welsh jurisdictions, and there has been a degree of convergence. Lucy.
And I mean, there are other issues as well. You know, we still have remaining outstanding issues in the divergence, don't we, Gareth?
Yeah, I think we do, Lucy. And the one I was going to talk about today was the potential divergence in relation to site sharing and upgrading. And in particular, I was going to talk about the Scottish case of Cornerstone against Thomas Stewart Fotheringham, which was a decision of the Lands Tribunal for Scotland published in July 2020. The background is it was an application for code rights under para 20 of the code, and it concerned a large estate in Perthshire. Now, the Tribunal's decision dealt with a large number of issues, but for today's purposes, what we're interested in particular is what the Tribunal had to say about the applicant's site sharing rights. And the dispute came to be whether the sharing rights under the agreement to be imposed should be confined to the rights provided for at para 17 of the code, or whether the operator should be given unrestricted rights to share the site. And as most of you listening will know, what paragraph 17 of the code says is that site sharing and upgrading is possible, but so long as two conditions are met. The first being that there's no adverse or minimal adverse impact on the appearance or visual amenity of the site, and secondly that the site sharing or upgrading doesn't impose any additional burden on the other party, and that can be an adverse effect on the enjoyment of the land by that party, or it can be an adverse effect in the sense that it causes additional loss, damage, or expense. So the first point that the Tribunal had to consider was whether it was in fact competent for it to award sharing rights which went beyond those provided for in para 17, and it fairly quickly concluded that it could, and in fact that had been a matter of agreement between the parties. But the critical question was whether the Tribunal should award rights which went beyond para 17. And essentially what the Tribunal in Scotland says was that Parliament must have had in mind the importance of site sharing when it enacted para 17. And so it took the view that para 17 represented a balance between the interests on the one hand of the operators and the general public, and on the other hand in site providers. And it settled on what it regarded as a test of there being pretty compelling evidence to justify the imposition of an agreement going beyond the provisions of para 17. And in addition, it said that the burden of establishing that compelling evidence existed sat with the operator rather than the site provider. And in the circumstances of the Fotheringham case, the Tribunal considered that those circumstances did not exist. And I think it went so far as to say that the concerns which the operator had articulated to the Tribunal's mind seemed more imagined than real. But I'm conscious, Oliver, that quite a different approach, I think, has been taken south of the border.
Yeah, thank you, Gareth. That is right. Although it's also fair to say that the question remained very controversial for a long period of time, because if one reads the code, one doesn't find the word share amongst any of the code rights in paragraph 3. One does find the word upgrade, but not share. And one finds the words upgrade and share in paragraph 17, where, as you very clearly explained, Gareth, there seems to be some sort of parliamentary balance as to the extent of that power. The other side of the argument is based on essentially picking through Lawcom 336, the underlying Law Commission report, and then through some of the changes that have been introduced by the new code. So the starting point in Lawcom 336 was that there is a chapter devoted to the question of upgrading and sharing, and a series of paragraphs devoted to the vexed question of whether there should have been an automatic unlimited right to upgrade and share. The Law Commission was of the view, having looked at the evidence from the consultees, that it would not be appropriate for operators to have a default is the key word here, automatic right to upgrade and share, because of course, although that might be innocuous inside a fiber optic duct, because you don't care how many cables are in there because it's underground, you might very much care if it's the roof of a building and suddenly you find, assuming that it's technologically feasible in the first place, that it begins to look a bit like the back of a porcupine with various bits of electronic communications apparatus on it. And because the Law Commission was concerned to make sure that that didn't happen as a matter of automatic entitlement, what the Law Commission said was that they would only be prepared to grant a right which was no skin off anyone's nose, if I can put it like that, so minimalistic that nobody in their right mind could object to it. And so they said, well, the fibre optic cable and the pre-existing duct would be one example. The dongle within the existing equipment cabin that nobody can see because it's behind the metal door would be another one. In Ontower and Green, which went to the Court of Appeal, the Court of Appeal validated that approach of the upper tribunal, that it's that 17 does not carry any sort of presumptive force as to what an operator needs. It reiterated the points made by the upper tribunal that paragraph 17 is next to useless if you're a whip, which has is in the business, of course, of putting active kit onto its inert apparatus and arguably thereby immediately infringing the very low limit of paragraph 17. It also did not follow in this regard the Fotheringham convincing reasons, or however you want to weighty burden, or however you want to describe it, evidential standard. What the Court of Appeal said was that there's no special civil standard of proof that's applicable in this case. It's just that the court, looking at all of this, has to ask itself, well, given that you've got para 17, how does this all shape up? And if the answer is, well, I'm a telecoms operator that's going to be sharing its mast because I'm a whip or a sharer with future unknown technologies and future unknown sharers, then that is a reason for affording latitude within the terms of the agreement, a point that's all the more important at the moment because of the state of the law in light of Ashlock and Compton Beecham, which means that you can't come back during the lifetime of the agreement and seek additional code rights, which you had no need for at the outset. It's now necessary, at least from an operator's perspective, to future-proof their agreements to that extent. So that's I think where the divergence is. I'll be interested to see how that feeds back into the reasoning of the Scottish cases, because I mean the Court of Appeal will only be of persuasive authority in the Scottish courts anyway, won't it? It won't have any. It has no precedential force, as it were.
No, that's right. But I do think it will be something to keep a keen eye on, because I think the chances of that developing are probably fairly significant.
Again, just in Cornerstone against Marks and Spencer, a more recent Scottish case, there is a bit of a shift back towards the sort of English approach there. So I think they were very much kind of focused on the approach taken in Maple House, and again, granted unlimited upgrading there, but restricted sharing to 2 operators, again, because it was the 2 shareholders of Cornerstone. So that's quite important.
Yeah, and it's interesting as well, just to pick up on that, of course, that then when you get to Ontower and Green, you're dealing with what they call a neutral host whip, which isn't beholden to 2 shareholders, but is open to all comers. And indeed, some of those people might not even be operators at all. They might be, emergency services network providers or the RNLI or whoever it may be. And there, the identity of the operator is such that the reasoning from Maple House, the London and Quadrant case, doesn't really map over because it doesn't have that primary function of supplying infrastructure for 2 shareholders. Although Cornerstone has now, of course, shed its shareholders and is now a tower co of its own. So it'd be interesting to see how that feeds in.
Moving on to the Supreme Court cases, we've touched on them, and such is the uncertainty in the code that we've got these 3 cases that are all under consideration by the English Supreme Court. We've got Cornerstone and Ashlock, we've got Cornerstone and Compton Beecham, and we've got Ontower UK, formerly Arqiva, and AP Wireless. Oliver, you have briefly touched on Ashlock, and I appreciate we're not going to go into the specifics of that case because it is actually one of yours, but could you just take us through some of the issues in the code and the seemingly omnipresent Landlord and Tenant Act of 1954?
Yeah, so it's interesting, isn't it, that when we were putting our heads together in advance of this session, I think I'm right in saying that we identified 4 cases of different levels of non-bindingness, which had been decided under the old code, and that the old code really had yielded very little by way of judicial dicta, whereas the new code has raced up the appellate structure and has yielded a Supreme Court case fairly shortly after it's coming into force. The issue in the Supreme Court, which the Supreme Court will need to consider, is the extent to which the relevant person under Part 4 of the code applies in circumstances where operators have a pre-existing use being made of the land. And essentially the issues before the Supreme Court are what happens if an operator is holding over after expiry of its code agreement? What if an operator has a subsisting agreement, whether code or outside the code because of its oral? And what happens if the operator has an agreement of that kind, which is a 1954 Act tenancy? Does Part 4, as the operators were contending, apply in all those cases, so that subject to the paragraph 21 imposition test being met in each case, an operator could seek new or additional code rights? Or is it the case, as was being contended for by the site providers in that case, that because in a common law sense, in a purely factual inquiry sense of walk to the site and kick and ask yourself whose stuff you've kicked, the occupier and hence the relevant person is the operator, and the operator has thereby, as it were, snooked itself. It can't access anything under Part 4 of the code. So that is the issue that the Supreme Court is going to be grappling with. It had a huge range of submissions before it, and what was quite fortunate was that we had 3 different varietals of these cases. We had Compton Beecham operator with no rights. We had AP Wireless operator with tenancy at will, oral, hence outside, transitional provisions, and then we had the 54 Act version in Ashloch. And I mean, essentially, the position that we've reached with the cases as they stand at the moment, subject to whatever the Supreme Court might decide about them, is that in each of those cases, the operator can't freshen up its agreements, or if it has no agreement whatsoever, regularize its position and seek new agreements due to the restrictive, the operator would say, reading of the code. And you know, it is of practical relevance that operators can't access code in those circumstances, because they then can't secure things that are code rights, which are special statutory privileges, which have certain consequences about binding other people, about rendering lawful conduct, and about accessing, of course, the paragraph 24 consideration assumption. So it is a highly significant issue, and hopefully the Supreme Court will give us some clarity on that soon, although the aspirational, I think one can say, lead in time, so those judgments are between 8 and 12 weeks, so we may need to wait a little bit.
And Gareth, you were just going to take us through the other case of Compton Beecham.
Yeah, thanks, Lucy. Well, the particular problem there, obviously, was that the applicant seeking the imposition of code rights was cornerstone in circumstances where Vodafone, another operator, was still in occupation of the site, having previously occupied it under a lease which had expired. And the fairly simple point there came to be, who is the occupier in those circumstances, to whom an application for the imposition of code rights ought to be directed, and both the upper tribunal and the Court of Appeal ultimately concluded that that was a question of fact. And at the point that the application was made, it was Vodafone in occupation of the site rather than Compton Beauchamp as the landowner. So it would be very interesting to see in which direction the Supreme Court jumps. I mean, Oliver, is the answer, as the Court of Appeal appeared to suggest, that Cornerstone and Vodafone themselves enter into an agreement and then seek to have the landowner bound by that? Is that, given the current statutory framework, the route through?
Well, I mean, as matters stand, I think it's the only route through. The Court of Appeal certainly said that was the workaround that should be adopted. But I suppose, and this may just be me being a bit simplistic, but I always think that if you have to come up with a workaround, you might ask yourself whether you've gone the right way anyway, because it seems to me that saying you can get there by the scenic route might suggest that the main trunk road should be open to you. And that in many ways is one of the things. I don't want to sort of jump ahead because Scott's going to look at On Tower, but it's what I sort of in my own brain call the slightly to the left problem, which is If the answer is tear your mast down and build one slightly to the left on the same parcel of land where the occupier problem doesn't arise, you might ask yourself whether that's an entirely, sensible way for the code to have developed. I appreciate there'll always be hard cases, but I'm always a bit wary of, as it were, the slightly to the left solution. Why should you have to detonate yourself, detonate your legal interest, detonate your mast site physically and take it away for 5 minutes and then come back and reinstall? And that was really the problem that Judge Cook had in the case you're going to talk about, Scott, the AP Wireless.
Mentioned this at the start. So Arqiva, as it was then, had a tenancy at will that had followed on from an earlier written lease that had expired before the new code came into effect. Was contracted out of the 1954 Act, so no security of tenure there. And a couple of points that the upper tribunal had to consider. Firstly, was it a subsisting agreement and therefore protected under the transitional provisions? And as I mentioned earlier, the answer to that was no, it was not a written agreement, therefore did not have subsisting code rights and so could not utilise the Part 5 procedure to get a renewal. Also, the upper tribunal basically said its hands were tied in relation to Part 4 rights because, following on from Compton, Beauchamp and Ashlock, operator in situ is not able to use Part 4 to get new code rights when it's already in occupation, as was the case here. So, as Oliver alluded to, you had that kind of ludicrous situation of possibly just taking it down and moving it a couple of meters to the left or right, and you might be okay then. So that's the pointed appeal there, but it really swings on the Compton Beauchamp case as well.
Okay. Thanks, everyone. Okay, so our third theme topic for today is looking at valuation. I think it's safe to say that in England, we've had a number of cases dealing with and detailing the new approach to valuation. And I think it's also safe to say that it's the most contentious change in the code from the old code. Obviously, valuation of the old code was a process which took into account the value of the site to the operator as a telecoms network, whereas obviously under the new code, that's all gone, and we have this valuation on the no network assumption. And Oliver, do you just want to take us through some of the issues around valuation, some of the cases that we've seen on valuation in England and Wales?
Yeah. I mean, I think the overall take on the valuation cases in England and Wales has been that there's been a gradual stabilisation of how we value these sites into a sort of orthodox approach. The upper tribunal has, I think, entirely understandably and correctly, been testing the water on different approaches to see how that valuation works. The early cases faced the difficulty that there weren't that many transactions to compare in the real world, and the tribunal's response to that was to develop what we call the Hanover Framework, which was essentially to sort of look at the alternative use value of the land, if any. So if none, then that would be a small nominal-ish amount. But if it was a car parking space or whatever it is, that is something that valuers are able to attach a value to. So that would be one element. Then the other element would be sort of a detriment to the site provider in having these rights exercised, because as the upper tribunals points out, it's a no network assumption. It's not a no kit assumption. So, in the strange hypothetical world of paragraph 24, somebody decides to install a mast that does nothing and then decides periodically to pitch up and alter and repair and improve it, even though it does nothing. But this eccentric person is nonetheless creating a problem for the site provider because they have to afford access and they have to tolerate visits and so on and so forth. So that is then generally all part of the framework. It's all in the mix. And those elements are then aggregated together, along with any additional benefits that might be capable of being monetized, and essentially you sort of break the agreement down into those sorts of components, and then you value them, and then you aggregate them. That's obviously a little bit rough and ready, and the tribunal acknowledges that, because the tribunal says, well, look, the gold standard is that we have open market new lettings to compare with, but absent that, we've got to do the best we can. But, you don't value a car by breaking it up into an engine and a steering wheel and a seat and then valuing each one of those individually and then totting them up. But so the tribunal has developed these valuation hypotheses through the early cases, but has now, I think, in two recent cases, Morris and the Affinity Water case, has sort of slightly rode back from the Hanover valuation framework, because the tribunal has observed, particularly in I think the Morris case, that there is now a sort of functioning market of comparables that are out there, and therefore we can do a proper comparison with other agreements, and we don't have to worry about the absence of evidence and making up for that with the Hanover framework. So we're getting towards a much more familiar method of valuation, which is based on real world transactions, which are, after all, the surest guide to the value of anything. Coupled with that, the tribunal has developed something, I'm not sure it would accept it is that, but it's something approximating a tariff. I think the tribunal has said, well, look, in essence, a rooftop is a rooftop is a rooftop, and a greenfield is a greenfield is a greenfield. And I should say a greenfield in telecoms talk includes brownfields and industrial estates and everything else. But generally speaking, those are the two categories of sites. And the tribunal has more than once said it'd be quite surprised that a rooftop in Birmingham would fetch more than a rooftop in Aberystwyth and a rooftop in Hull, or a rooftop in London. I mean, there may be special features for the underlying property that means it has an alternative use value. There may be different compensation issues arising, loss of development, or whatever it may be. But the tribunal, I think, is quite keen to make clear that the parameters are quite narrow around these values. And I think that's probably done with a view to its overarching concern that people are spending too much money and wasting too much paper on having debates about whether it's plus minus £120 a year.
Presumably, when we're talking about the comparables, we don't have comparables for everything just yet, do we?
No, I think that's right, and there will have to be adjustments. But I think, I mean, I don't presume to speak for Gareth and Scott's experiences, but certainly in England and Wales, what I am seeing is fairly standard term agreements, and those standard term agreements might have the odd bespoke clause if there's something specific about the site, or if there is, if there's a particular access problem. I mean, one doesn't need to have an overactive imagination to think that an access protocol for a roof on a secure prison or a secure hospital might look rather different from an access protocol to a roof of a factory unit on an industrial estate.
Or some sort of lift and shift provision, or the like. Yeah. Sorry, go on, Oliver.
No, but of course, I should say, in many cases, I think most valuers would accept, as they do in the 1954 Act, that there are some clauses that do make a difference to value, but some clauses that really just don't make a difference to value, or the difference is so small that it's really not worth getting too excited about. So we are, the short answer to your question is I think we have got quite a lot of information out there. We're still trying to find proper bodies of renewals, of new lettings rather than renewals and so on. But the new agreements seem to be shaking down in quite similar forms, I think.
And Scott, Gareth, just on valuation north of the border, what's happening there?
I would say fairly similar, actually. I think the kind of two key cases, there's the Fothering case that dealt with a greenfield site, and so the values there were fairly similar to Greenfield's values down south. Interesting feature of that case was that the first year's rent was actually a lot higher than subsequent year's rent, to reflect the imposition of the installation of the equipment, obviously being more of a burden on the landowner at the start of the lease than later on. And then again, the Marks and Spencer case, that was a rooftop case that considered values there, and again kind of followed that three-stage approach that was used in the English cases as well. Just picking up on Oliver mentioned the standardised documents. Again, that is a feature that we're seeing more of in Scotland. The Infralink project are running out standardised documents that are available for use throughout Scotland. They've got templates for greenfield, for urban, for rooftop and land as well. So they're very useful, and the pick up on both sides of the divide, both operators and site providers, has been encouraging there.
Are those standard documents, Scott? Are they following some of the valuation decisions that have come out of England and Wales, or are they very much standalone?
They also have standardised payment guidance as well that has been prepared on the basis of the valuations coming through both tribunals north and south of the border.
Excellent. Okay, so looking then to the future, we've now got sight of new proposed legislation to implement changes to the code, and that's in part 2 of the Product and Security and Telecommunications Infrastructure Bill. I will put my teeth back in, and the draft bill is following a government consultation into the code that was way back in January 2021. And that consultation sort of views from industry on a number of issues in the code, and we've sort of illuminated those issues. I think sort of perhaps quite humorously to a lot of us, there was bold text in that in that consultation documentation that essentially said, government was not going to revisit the valuation methodology. We all need to really get over it. Just on the other issues that are highlighted, from the consultation and have been pulled through into the new bill, Oliver, we are actually hoping, with all these issues around the 1954 Act, we are actually hoping for some sort of harmonisation between the code and the Act. And for those of us practicing in England and Wales, what should we expect from this legislation, and what's it going to look like in practice?
Well, I think on that issue that you've just raised, the idea is going to be that there's a special Section 34 rent valuation hypothesis under which essentially the paragraph 24 considerations are being aped. The reason why that is the case is at the moment there is a divergence between renewing a 54 Act tenancy, that's telecoms, and renewing under the code, because in Hanover, the county court, which was the upper tribunal sitting as the county court, determined that there could be a differential answer, because under Section 34 you didn't have to disregard the network, and because you don't have to disregard the network, you don't have to disregard competition for sites, and therefore that could, in the hypothetical transaction posited by Section 34, lead to operators bidding against each other. That position has been slightly called into question by the later cases and Morris, because it seems to be suggested in that case that neither valuer really thought that was part of the hypothetical negotiation. I think probably rightly, because if you have two operators clamoring for one site, the most likely outcome is that one's going to take it and the other one's going to share it, rather than they're driving up the site value by bidding against each other. I suspect that would be the real world answer, would be my view. But then in the later cases, they were taken into account by the tribunal sitting as the county court again, some early completion payments, incentive payments, which had previously been treated as not a feature of either Section 34 or paragraph 24, because in both hypothetical worlds, everyone was a willing participant in this transaction. But I think the upper tribunal, the county court, upper tribunal sitting as a county court in the later cases said, well, that's not true of all of them, and some of them fall to be rentalised. So there is this divergence. And I suppose the divergence is hard to justify if at the end of the day what you end up with by either route is exactly the same kind of agreement with exactly the same sort of security of tenure. Then why should you be paying a little bit more for one than for the other? That would be the argument. So I think that the bill is intended to address that, as I say, by harmonising valuation hypotheses for leases which are going to become code agreements. So that's one of the main features. The other features that are going to be looked at are the occupier question, which is the question before the Supreme Court. I detect in the response to the consultation an appetite for reversing Ashloch and Compton Beecham, and that seems to be what is meant to happen with these changes to occupier, albeit that I think the drafting needs to be looked at a bit more closely again. The other thing that's being included is the access to residential properties in the main where landlords are unresponsive, which was something that was trailed much earlier on than the general reforms, and has been through a variety of iterations.
One observation on the bill is, are we realistically going to see an explosion in alternative dispute resolution in the telecom space?
I think
I'm not holding my breath on that.
No, I think you're right, Gareth. I mean, what I think the hope has been expressed by a variety of parties is that once you begin to settle down on the valuation, which had been the main problem for most of the code, that maybe there would be more space for that to happen. But I think what's happened instead is that once that point's been resolved, the debate has now moved on to other issues. So that what you find is that, yes, the core of the code agreement has been agreed, but that, for example, people are trying to have a debate about whether you get in-term rights or whether there are certain rights that you're going to get which need to be valued outside code. And I think the problem is that the problem at the heart of this is, as Lucy indicated, is the decline in code rents has incentivized these kinds of debates to try and make up, insofar as they can be made up, the lost ground, in inverted commas, from the old world. And I just suspect that unless ADR carries a big stick, a cost stick, for example, I think you're probably right in your assessment.
Yeah. Okay, so keeping with the future, because we are all looking to the future, this is wondrous technology that we're all moving towards. Where do we feel, or do we have any sight, perhaps any speculation on where future pinch points within the new legislation, the existing code, that are likely to result in dispute in the future? Oliver, any insights on that?
I mean, in the immediate short term, I would say that what we're going to be doing is reading part 5 of the code a lot more than we maybe have had to in the first couple of years, because I think that a lot of these, not the newer code agreements that have been negotiated, but the transitional code agreements are now largely coming up for renewals or coming up for termination notices or whatever it may be. So I think that Lucy, Gareth and Scott, you're going to be leafing around in that bit of the code a bit more if you haven't already been. And then I think the other thing that I'm interested in is not based really on any direct experience of this on a large scale, but just if one follows technological developments and if one follows the interesting material that's posted on LinkedIn by non-lawyers about telecoms, you begin to see that street furniture and benches and bus stops and bins are all being repurposed to host smaller cell sites or other kinds of telecoms infrastructure, hotspots or whatever it may be. And I just wonder whether we are going to have to start looking much more carefully at the special regimes, the transport land rights and all of this kind of material, as technology moves away from just really utilizing large private land holdings and focuses instead on repurposing the public realm. So I think that may be where we are.
Shifting to the left.
Shifting to the left onto the highway.
Scott, I know you've been doing some stuff around that, haven't you, around the streetworks?
Yeah, so I guess I would just echo some of the things that Oliver is saying there. Again, I can see some disputes arising in relation to the kind of Part 5 process. And I think particularly in Scotland, pending the reforms coming in, we've got this issue about rooftop licenses and whether or not they would be protected by Part 5. Another kind of issue with Part 5 that I've been grappling with and I've not quite got to the bottom of is the notice period for termination of subsisting agreements in Scotland, where you've got tacit relocation running. So under the transitional provisions, it's a reduced notice period, but that doesn't sit very well once your lease has been running in tacit relocation for a further, what's that, 4 or 5 years now. So that's definitely one to take a cautious approach with, but I could see that being litigated at some point. And then, yeah, on street works, that's quite an interesting one as well. I've been dealing with a couple of situations where apparatus was installed under old code streetworks rights a long time ago, and the road is no longer a public road, and so the issue arises as to what is the status of that apparatus now. And the current code, the sort of removal provisions in relation to streetwork rights are a bit confusing, because it provides that there will be an entitlement to remove streetwork rights where it ceases to be, the land ceases to be part of a public road. But there's also then a reference to a procedure having to go through that only applies to transport land rights. So my reading of that is that particular provision cannot be met, and you then have to look at specific provisions elsewhere that deal with stopping up of roads and so on, paras 40 and 41. So yeah, I think these areas could well be litigated on in the coming years.
Excellent.
Yeah, I mean, I think that there's generally Part 6 generally throws up quite a lot of conundrums of that kind, doesn't it? For example, how do you serve a notice of an operator when the reason you want them to be removed is that they've ceased to be the operator? I'm sure it requires closer reading than that, but every now and again I sort of think about that one. And
Well, there we have it, a conundrum for the ages.
There we go.
Okay, so it just leaves it to me to sort of wrap us up. It's been a great session. Hopefully we've managed to unpack some of the issues faced by operators, site providers, occupiers, those of us working in the area. Just for me to say a thank you to Oliver for joining Gareth, Scott and I today. Thank you. It's been wonderful to have you on today's session, so thank you.
Well, thank you for a very interesting discussion, all of you. Thanks very much for inviting me.
Brilliant. And thank you everybody for listening, and please join us next time. Thanks.